This point, we'll turn to the second case, and I understand that there needs to be a little bit of choreography change, but that case is case 127547, also from Johnson County, State of Kansas Appalachia versus Uzziel Badillo-Villalobos, appellant. And would the parties please state their appearances?
Good afternoon, Your Honor. May it please the court. The State of Kansas appears by Jacob Gonzalez.
Thank you. And counsel, would you like to reserve any time for rebuttal?
3 minutes.
3 minutes are granted, and you may proceed.
As you said, I'm going to try to focus on what's important instead of trying to take a shotgun approach. This case was a one witness case, meaning that one witness said that she was raped, as she had fallen unconscious, and then she had been raped by the person who was accompanying her or had non-consensual sex. However, the video from the hotel in this case showed her walking to the hotel room on her own. Now, her testimony was that she had fallen unconscious long before she got to the hotel, or before she got to the hotel. But the hotel video showed her walking up the stairs on her own strength and then going into the room. So, and then in this case, the investigation consisted of an interview with the alleged victim, an interview with the alleged defendant, and the video from the hotel. At the end of the trial, during the testimony, the prosecutor asked one of the detectives if the defendant had answered a question or admitted that the alleged victim had told him to take me to my car, and instead he took her to the hotel. His answer was no. However, the detectives on the stand said yes. Then the prosecutor tied it down real good.
Counsel, just to be clear, was his answer no, or was it just that question didn't get asked?
No, it
was my understanding that after reviewing the video, that the question was, what did you talk about, or something along those lines? And he said, I can't remember because I was drunk. We were both drunk.
Yes, Your Honor. If you look at the transcript for the new trial, I specifically asked that detective. And then I asked the other person who was in the interview, Diaz investigator, who was in the interview room. I asked both of them that did he ever say that did he ever admit that the lady had told him to take me to the car, and instead he just went to the hotel. They didn't have it in their report. The law enforcement detective Murphy said no. She don't remember him saying yes to that question. But
would that have been the correct answer from the detective? That I don't recall, or he didn't answer the question. I think where we're getting a little tied up is, she makes the statement on the stand. Yes, he said that. And then when you look at the video, it's not that he really said, no, I didn't. It's just more of, did he ever really answer the question? Does that make sense?
Yes, but my position is, if you look at the testimony or the motion of the new trial, I specifically asked him, and she said he never said that I heard her say, yes, take me to the car. And why that is important is because in the closing argument, then the prosecutor uses that to corroborate. She says that corroborates the testimony. And unlike the state's position, she didn't use it one time. She used it at least on 3 different times in different ways, that he corroborated the testimony that she told him to take her to the car. Then he took her to the hotel without her wanting to go to the hotel. And he did all those things. That's where the case turns. That she got into the car and she says, take me to the car. And he just decides to take her to the hotel anyways, after he clearly heard her say no.
Counsel, I'll tell you, one of the things that I am having difficulty with is because that interview was not offered as evidence at trial, because that question was asked and the answer was given that you've pointed out, but there was no objection, that just came in as evidence. So is it improper for the prosecutor to talk about the evidence that was submitted at trial?
No, and that's a good question. Is it a state v. Killings issue or state v. Science? I believe, if I'm pronouncing that right. The question here is not that evidence, it is a prosecutor's duty not to have evidence into the trial that is not true. It is not, that's not supported by
how is the court to know whether that evidence was true or not if that interview was never offered as evidence? I mean, that's what I'm having, like, how are we supposed to know whether that evidence was true or not? And certainly there was testimony given at the motion for a new trial that called it into question. We can watch the video that was offered at the motion for a new trial, but at the trial, how is the court to know?
So you're right. My issue with this is not that at the new trial, the judge was provided with the video, the interview. The interview was 2.5 hours long in 2 different languages.
I've watched it.
Yeah. So the question, our argument is the prosecutor knew that he'd never said that. The prosecutor had that evidence. The prosecutor had the video. The prosecutor had the police reports. She had all the evidence that I presented at the new trial, for motion for a new trial. So she had all the evidence. It was her duty to make sure that that mistake should have been corrected. Yes, at that time, because there were so many languages going on, I was confused. Did I miss something between the translation or something? That's why I didn't jump up right then and there. But this trial went on and the prosecutor had time to go then check it and see, well, that's not true. So well, my argument is,
if no one alerted that was an issue, I mean, that's what, assuming it was an issue, because I think that there's a question about that too, that your opposing counsel has pointed out in the brief that the question was kind of phrased in a different way during the interview. Like she asked you to take her to her car, right? Or something along those lines. And your client nodded. Now, whether that nodding was in response to that question or something else, perhaps that's a factual question, but at least it looks like there was a question that was asked and a response given. So this is very messy.
It is, Your Honor. I agree with you. But keep in mind that nod was never presented to the jury because they were never shown the video. So they could have not, all they had was what the detective said, and then the prosecutor tying that, like, look, even though she was conscious, she was walking, but he corroborates her testimony. So that is where the problem lies. Yes, it would have been a lot more cleaner, I agree with you, if I would have just jumped up and objected at that moment and then said that. However, I did object at the closing, during the closing, because by that time I had double checked I had to get somebody translate because most of the video was not translated. It was talking back and forth in Spanish. So I thought I may have missed something because when she asked her that question, that was such a big admission, I thought, that there could not be. Maybe I had made a mistake. But at the end of at the closing, when she argued, I did object because that was not the proper evidence. So I think, given that the case was so close, and given the credibility of the alleged victim was so crucial, even the judge said that, and it was damaged because she was supposed to be unconscious, yet on the video she is conscious. I think those little things, like this kind of evidence, made the difference between the jury's verdict. And as you know, the judge said the jury deliberated for quite a while, but at the end they found him guilty. So I think our analysis is, would that have made a difference in jury's verdict? I definitely think that would have made a difference in jury's verdict. And that was one of the things. Now I've listed other things in my brief. I will not belabor you with those, but that, I think, the biggest problem with this case was saying, one, that the defendant's testimony, the alleged victim's testimony is corroborated by the defendant when it was not.
So you've alleged 9 different instances of prosecutorial error. And I agree. I think this is the one that stands out to me as well. But what other of those 9 do you want to draw our attention to?
So for example, in the thing that the evidence was that the victim was out with the defendant and they were at the concert and he was buying drinks. And then when he ran out of money, she started buying her own drinks. The prosecutor was like, he tried to ply her with drinks when of course she was buying her own drinks. He wanted to buy drinks. And then the other bigger one that comes to my mind was when saying that the blood test was negative for alcohol. And the prosecutor said, well, the negative test can be confirmatory. Now, in the case, the allegation was that the alleged victim was so intoxicated that she could not consent. The blood test was negative for alcohol. And the prosecutor is like, well, that is confirmatory to the evidence, which is not. And also she said the Detective Murphy's testimony or the evidence was, Detective Murphy's testimony was on point or on evidence, when you can see the videos show completely different story. So those are the things. I can look them up real quick, make sure those are.
Question about one of your claims.
Yes.
I think you made a claim that the prosecutor misled the jury about the legal standard of the term unconscious. Can you
Yes.
talk to us about that?
Yes, thank you. Thank you for reminding me. That was an important thing, because at the probable cause hearing, Detective Murphy, the prosecutor asked that Detective Murphy, if somebody can black out and still and not know that they had sex and such. And then I asked Detective Murphy, is that possible that somebody can black out and consent and not know that they had consented? And Detective Murphy said yes. So when at the trial, when I started going down that road talking to Detective Murphy, the state objected and told the jury that we will have a definition of unconsciousness. He does not need to question the detective about unconsciousness. We will have testimony of, we have our definition of unconsciousness presented to the jury. The judge sustained that objection and stopped me dead in my tracks. That never happened. At the closing of the evidence, the state wanted to have some kind of definition for the jury, which the court eventually denied. So they didn't have a definition of unconsciousness. And so then the state then came up with this idea that unconsciousness means somebody to be unaware. Not being unaware means you were unaware of a snake in your arm in the grass, you're unaware of somebody sneaking up on you. But unconscious means, in this case, being out cold, being completely unconscious. So I think that was a problem also, where saying to the jury that they're going to have a definition, then not having a definition, and then providing them a definition that suits their case. If I think I'm out of time, if any other further questions.
Other questions?
Thank-
All right, thank you very much. We'll look forward to seeing you on rebuttal, and counsel, you've got 15 minutes. This is a messy case, counsel.
I agree, Judge. Absolutely it is. That's one claim I will not dispute. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas in this case. This appeal presents 2 fairly narrow questions, neither of which warrant disturbing the jury's verdict in this case. First, the defendant alleges numerous instances of prosecutorial error. The second claim relates to the Jackson v. Deno hearing. I'm happy to respond to questions about the Jackson v. Deno hearing if this court has any, but absent those, I'll address the prosecutorial error claims first and attempt to do so in the order that opposing counsel did so. That first, most substantive claim regarding prosecutorial error rests on the mention of the victim telling the defendant that she wanted to be brought back to her car after they left the concert. This is a messy case, but if this court takes the time to go through the record, what this court will find is that the prosecutor never elicited false testimony. When the officer was asked on the witness stand whether the defendant acknowledged that the victim asked to be brought back to her car, the officer said yes. There was no objection made, as this court already noted. And in the motion for new trial, after the verdict, that's when the officer got back on the stand and was asked again about that exchange. And at that time, the officer equivocated. The officer hesitated and said she didn't recall exactly what he said. She was not as certain. When Murphy was asked directly in the hearing, did the defendant admit to you that the victim had asked him to take her to her car? before they went to the hotel? Then Murphy responded, no, he said he didn't remember what they talked about because they were drunk. That would seemingly conflict with her testimony from the jury trial. But if this court goes back and looks at the actual video, and I acknowledge, the state acknowledges that video was not played for the jury, but the question before this court is not what the jury made of this, it's whether or not the state elicited false testimony from that officer. And if this court goes back and looks at the video, the interview of the defendant, what they will find is the conversation between the officer and the defendant. The officer asking, when you decided that you guys were going to go to the hotel, what was your decision-making process? Like, why did you decide to go to the hotel instead of taking her back to her car? That's what Murphy asked him, to which the defendant responded, or what? And the officer then said, so you took her, the plan was to take her back to her car, to which the defendant appeared to nod in the affirmative, if this court watches the video.
Counsel, I have watched the video and I am unclear from watching that video whether that is a nod yes or a nod just kind of as a person is talking, because he tended to do that a lot during the video. He would just nod as the detective was asking, almost as though to show that he understood what was being asked. What are we to make of that?
What you could do is put that in the context of the entirety of the video, and you can recognize that there were times that the defendant did speak up when he disagreed with the premise of the question. And this is not one of those times. This is one of those times when the question was presented to him that included a statement of fact about the plan was to bring her back to her car. And he nodded. And then she got to the rest of her question, to which he then responded. And he never pushed back on the premise of the question. And this court can infer from that he was nodding in the affirmative to the premise of the question, which was that she asked to be taken back to her car. With that information, even if this court sees that as equivocating or unclear or uncertain, at least that certainly does not provide corroboration that Murphy testified falsely in the jury trial, or that the state elicited false testimony from her in that jury trial. That review of that video can demonstrate that at best people could disagree. More likely people could recognize that the defendant was acknowledging the premise of the question when it was posed to him.
If we disagree and we conclude that that's not our conclusion based on the video, how are we to assess harmlessness here? Because it is a credibility case. And what I have trouble with about this case is that the only credibility with regard to the defendant, and this often happens when the defendant doesn't testify, is just summaries as to what other people say that the defendant said. Right. And here we have a statement that is arguably false about what the defendant said, and then we're using that statement to bolster the credibility of the complaining witness. That's hard.
And I'll add to that, like the specific statement that gives me heartburn is that the prosecutor said that Jane's testimony could be believed, and I'm using Jane as a pseudonym, because the defendant tells you that also, right? So those two things are corroborated. He also said that she told him to take her to her car. So it's the initial problem of the testimony not being truthful, but then the second gut punch of using it in closing argument to say, hey, we've corroborated our facts with it. That's just so troublesome to me.
I could see how that would be troublesome if it was a false statement, and the state maintains it was not. Review of the video the state maintains demonstrates that was not a false statement of what Murphy's exchange with the defendant was.
But the prosecutor says, because the defendant tells you that, even if you interpret a nod as a nod, he never said that.
In literal words, he did not. That's absolutely true. Colloquially speaking, that's what the prosecutor was doing in closing when she was saying that he says as much. And we often say that about testimony all the time. We say that the witness said XYZ. They may not have said XYZ from the witness stand, but when they were asked, is XYZ true? And they said yes, then we say they said XYZ because they adopted the premise of the question and they affirmed it or they acquiesced to it. And that's what occurred here. So this,
And I'm not implying that the prosecutor acted in ill will, or I mean, no disrespect, but should the prosecutor, having prepared for trial and having reviewed the videos and the evidence, known that statement was not correct?
with the state's review of the video, I don't believe as though the prosecutor should have known that that was incorrect because the state maintains it wasn't incorrect. And that's why the video being admitted in the motion for new trial was the way for the state to vindicate the arguments that it made. The same holds true for.
Did the district court have the opportunity? I mean, had the opportunity, but did the district court review the video again? It didn't look like that happened.
I was not there. I cannot tell you if they did.
Yeah, it looked from the record as though that had not occurred and that the judge was recalling a previous, I'm assuming, because it wasn't during the trial, so maybe it was preliminary or something along those lines when the video was shown.
It absolutely could have been. It could have been. Although the district court's review of that video and what they made of it is, I would argue, essentially irrelevant here to this court's determination, since this court's already getting into the minutia of the video that it has before it. Although under an abuse of discretion standard, obviously, substantial competent evidence supports the district court's fact findings that no misstatement was made. And then this court would review de novo the legal conclusion that was drawn therefrom. But I believe as though this court has sufficient evidence to support the district court's conclusion that this was not an error, that it was not harmless, that it was not harmful, excuse me.
And I just want to make sure I understand your position. So you're saying if you look at the video, the fact that the defendant nodded means that he answered the question in the affirmative. Is that what you're saying?
Absolutely.
Because my problem with that is when you look at the actual exchange, the prosecutor asked Detective Murphy this: did you ask him if Jane had told him to take her car? Yes. And what did he say? She did ask him that. So he said she did tell him to take her to the car? Yes. He never said anything. I mean, that's the problem. She could have said he nodded, or we didn't really get an affirmative response. But, this presents a message to the jury that he vocally answered the question.
And that was not objected to. And the defendant could have pushed back on that too. The defendant could have pushed back on it in cross-examination. The defendant could have admitted the video to clarify and impeach the officer. And the defendant did neither of those things. What happened in that exchange with the nodding when the premise of the question was made by the officer is what the state maintains justified both the question and answer from the officer on the stand and the state's summation of that in closing argument. The state's argument on, and I'm trying to hit on some of the other claims that opposing counsel had addressed here in argument, the state's argument on the meaning of unconscious. If you look through the actual statements made by both counsel, the defense said unconscious means somebody did not know. And that's precisely how the state had captioned consciousness or unconsciousness. The proper definition in Black's Law Dictionary is without awareness. And so the state maintains that it never misstated the definition of unconscious. In fact, the state had requested a definition be provided to the jury. The state anticipated one would be given, but it wasn't. In terms of plying the victim with alcohol, the claim made by opposing counsel is that the state argued that he had plied her with alcohol. The evidence was that he did pay for the alcohol. He bought alcohol for the victim, and then he unilaterally made the decision to take her to the motel. Rather than back to her car. On the toxicology results, this is another one where the opposing counsel misframes the actual statement that was made by the state. He argues that the state told the jury that negative alcohol results were confirmatory that the victim was drunk. That's absolutely not what the state said in closing argument. If you look at the literal words chosen by the state spoke about the test results and said, opposing counsel wants to talk to you about those negative test results, but those are a red herring. You heard from the toxicologist, and the state didn't use the word negative in the phrasing. The state said, these are important because they can be confirmatory. meaning
What does that mean?
that means these test results can confirm the presence of alcohol in someone's blood, but absent a result showing a positive doesn't affirm the negative. It doesn't mean that they didn't have alcohol in their blood 12 hours ago. And that's where the state then drew on that by saying, you heard from the toxicologist about how alcohol is depleted in how it gets metabolized and how it gets reduced over time, and that a negative result 12 hours after does not confirm that somebody was sober 12 hours earlier. That's the statement that was being made.
I mean, it seems a little different, right? I mean, that these can be confirmatory means, I mean, that's different from saying this doesn't negate the possibility. Confirmatory, in my view, means these can prove what the state is saying. And that's not true. It's just that these can, these don't disprove.
Correct. And if you look at the context in which the statement was made, that's the whole point that the state was driving home, is that these results showing negative do not confirm that she did not have alcohol in her system. After all, both parties abundantly agreed that she had a lot to drink. The defendant acknowledged that repeatedly. He knew, not only did he buy her the drinks, he knew she was drunk. He stated that repeatedly. So
that actually brings us back to one of the earlier comments. So one of the prosecutorial errors alleged is the ply her with alcohol comment. So it looks like the appellant is saying that the victim told the officer that she actually bought her own drinks because the defendant ran out of money. Can you address that statement?
that is what happened later on as the night went on. He purchased drinks too. She also purchased some when he ran out of money.
So on the front end of the evening, he's buying the drinks. He runs out of money. And she's buying her own drinks.
After she's inebriated, correct. Correct. This case is one that comes down to credibility. That is what it comes down to. But it isn't just, as opposing counsel stated, a one witness case. Cases would be a rape case can be made on one witness, but this isn't made on one witness because it wasn't just one witness that testified against the defendant in this case. It was other witnesses who testified about statements that the victim made contemporaneous to her being raped. And the other information that came in also, like the surveillance video from the Motel 6, the surveillance video of the defendant standing over the victim in the car for many, many seconds before she could even get out of his truck and be taken into the room. Her stepping out of the room to go back down to the truck after these events and walking the wrong way and needing to be corrected because she wasn't aware of where she was or how she had gotten there. There's a lot of information beyond just the words spoken by the victim from the witness stand that corroborate the victim's testimony. And it isn't just the victim's statements that made this case. There was much more than that. There were the defendant's admissions about taking her there, about unilaterally making the decision to go to the motel, about having feelings for her, about having problems in his marriage, all the opposite things that she talked about never wanting a relationship with him and not wanting any advancements by him toward her. There was more than just her claim that she was raped that day. That is not solely what this case rested upon. Recognizing I'm out of time, I welcome this court's question.
Just one more question. So, I mean, doesn't whether or not she asked to be taken back to her car become a very important material fact? Because it's the point in the evening where either she wants to continue the evening with this gentleman or she doesn't. And I guess that's my question. Is that a very important fact?
I would say it's a very important fact, but I think it's relevant in the context of the entirety of the case. And I don't think this court is in a position to say that a reasonable judge couldn't view the information from that video and decide that that was not an incorrect statement of fact. I'd ask this court affirm the defendant's conviction and sentence.
Thank you very much.
Thank you.
Counsel, you've reserved 3 minutes for rebuttal.
I'm going to read the part during the motion for a new trial when I asked Detective Murphy, but did he admit to you that alleged victim had asked him to take her to her car before they went to the hotel? She said, no. He said he didn't remember what they talked about because they were drunk. So my question was, so the statement that you made in the trial, that would be incorrect, right? And she said, yes, that would have been incorrect. Now,
Counsel, and I'm sorry to interrupt, but if that is incorrect, we can't necessarily presume that the state knew that that was incorrect at the time that it was elicited at trial. And then when it was elicited at trial and the state argued the evidence in closing argument, what are we to do with after the fact finding out that evidence at trial was not accurate? I mean, that doesn't necessarily mean that there was prosecutorial error.
So my position, Your Honor, that the state raises the point that why didn't I play the video? Because the state had the video and they could have looked at the video. They could have looked at the reports. If you look at my whole cross-examination or my questioning of the detectives, they talk about not having this in their reports, both of them, and not having this in the video. And the reason the video was 2.5 hours long. And it had, most of it was Spanish. I cannot speak Spanish, so I do not know what they were talking about. Playing that kind of video as a defendant in front of the jury, that opens up all kinds of doors. Because I did not know what the Spanish language was. And also it had irrelevant stuff. So that's why they were not presented. But my position back to your question is the prosecutor should know about something that is so crucial in this case before they present evidence. And if they have made a mistake, they should call the court's attention that, yeah, they made a mistake. The prosecutor, even after the motion for new trial, stuck to her guns like, no, this is what it was. After I pointed her out any which way I could, that what she said was wrong. So I think that is important to note, Your Honor. And I believe I've got 31 seconds. So. Unless you have any other questions.
Other questions? All right, thank you.
Thank you, Your Honor.
Counsel, thank you very much for your arguments in this case. We will take the matter under advisement and issue a written opinion as soon as we're able, but we appreciate your thoughtful arguments both in writing and here today. With that, the court stands in recess until 9:30 tomorrow morning.
All rise.